Good afternoon to those who have joined. We will kick off in another 30 seconds or so. So good afternoon, welcome to this edition of Trinity Talks. Today the topic is OHADA. OHADA is the matter, comparing key issues in security documents. Presenting today are my partner Mariana Sedefian, who is based in our Paris office, and Senior Associate Lucy Johnson, who's based in our London office. And Mariana and Lucy will take you through today both OHADA security documents and how they work, and that will be a discussion led by Mariana, and a comparison between OHADA security and common law, English law security, and that discussion will primarily be led by my colleague Lucy. As ever, I'll open the Q&A box, so feel free to type in questions as you go along. And there will be a period of time at the end of today's talk where we'll be able to address any questions that you may have to try and keep a level of interactivity. So without further ado, we are going to talk. Here's just a summary of what we're going to talk about, taking security under OHADA law and then how it differs under the English and other common law systems. So for now, I am going to pass you to my colleague Mariana to kick off.
Thanks, Kaushik, and good afternoon, everyone. So first of all, I would like to say a few words about the specificity of the OHADA jurisdiction and actually what is OHADA. In 1993, 17 member states have created the Organization for the Harmonization of Business Law in Africa. So what is OHADA? This is not purely a political integration organization. This is merely a technical and legal organization. And it aims at remedying the legal and judicial insecurity by modernizing and harmonizing the member states' business law so as to encourage investments. In order to do so, the OHADA have adopted uniform acts, we say in French, acte uniforme, which upon entry into effect immediately are applicable in the member state, and these are national, superior to national law, and they abrogate national conflicting law. So this is really a very important thing to keep in mind when you do business in Francophone countries in Africa, mainly those 17 member states, is that wherever you are in Benin, in Cameroon, or in Mali, all the law applicable will be the same. So the OHADA Acts cover a wide range of issues: general commercial law, the Commercial Companies Act and the Economic Interest Groups, and also the Security Interest Act. The topic of today is with respect to the Security Act. So on the next slide, you will see that the Uniform Security Act organizing securities has been first adopted in 1997, and it has been further revised in 2010. So this is mainly an adaptation of the French position, French jurisprudence with respect to security in Francophone countries. What has been revised in 2010 is very important because, for instance, the new security agent regime has been implemented. Such security agent could be must be credit institution. It can be either domestic or foreign. And this is very important because previously we didn't have this kind of institution, which is very well known in common law countries, such as the trustee. And it allows to take security for the benefit of a security agent instead of having a list of various secured parties. One thing which is also important to keep in mind is that pursuant to the OHADA Security Act and further to this revision in 2010, we can secure future debts, which is quite important also to know, and future assets, as long as these are identifiable. New types of security have been also implemented, and also something which is very, very important, the enforcement of security process, the security interests have been eased. So in some circumstances, the appropriation is possible under OHADA law. So on the next slide, I will explain how we take the security under OHADA law. And on this slide, this fabulous diagram, we are trying to show you the various types of security that exist under OHADA law and generally under civil law. So you can see on the right the mortgages, and then on the left the personal securities. I will say a few words in a few minutes, and the securities of movables. And you can see this wide range of all security, the types of security. And this is something very important to keep in mind for everyone who is not used to deal in in civil law countries, is that you don't have any kind of floating charge covering all the assets of a debtor. It doesn't exist on the civil law systems. Instead, we have a security agreement covering each type of assets. So, as I have said, I have started talking about the mortgages. The mortgages are covering the lands, the immovable assets, personal securities. I will say a few words afterwards, and all this range of securities over movables, over stocks, inventory, professional equipment, bank account receivables, and so on. Each security is subject to some specific rules, and I will give you in a few minutes the most important aspects with respect of such securities. So on the next slide, I would just like to say a few words about some personal securities that are now implemented under OHADA law. We have two types of personal securities. We have the surety bonds, we call them in French cautionnement, but we can also call them the civil law guarantees. And we have also the on-demand guarantees. The civil law guarantee, this is the type of English law guarantee, corporate guarantee you may find in common law countries, whereby a party is guaranteeing over the debtor's obligations. This is important to know that this kind of guarantee is considered to be as an accessory to the principal. So the guarantor can usually avail itself from the defenses that the debtor can avail itself under the facility agreement, for instance. Something which is quite important to know and which is different from French law is that the civil law guarantee or the surety bond needs to have a maximum amount set forth in the agreement itself, which is different under French law. On the other side, we have the on-demand guarantees. So it was on the next slide, the slides there. The on-demand guarantees. The difference between the on-demand guarantees and the surety bonds is that the on-demand guarantees are independent, and they can be called without any possibility for the guarantor to raise any defense based on the underlying obligation. So this is merely a kind of very, very close to the LC instrument we know under the banking regulations, a very strong security that we commonly use under OHADA jurisdictions. So on the next slide, I would like to say a few words about the security of the receivables and to give some inputs with respect to the most typical security documents in project finance. So why receivables? Because the control of the cash in a project finance transaction is key. So usually we take security over receivables over the bank accounts, the onshore bank accounts, and also the receivables which are arising under a given contract. Here, something quite interesting and important to note is that under civil law countries, we cannot pledge nor assign a contract nor the non-monetary obligations, which is quite different from the English law assignment agreement, whereby it is possible to pledge the contracts and the contractual rights. Here, under civil law countries, you need to combine the pledge with a direct agreement in order to reach the same result as under English law. Insurance policies can also be pledged, or they can also be assigned by way of a delegation, which is actually a tripartite agreement whereby the insurance company agrees to pay the lenders insurance proceeds in respect of a given project. So on the next slide, I would like to go into deep details onto the pledge over receivables, because we have two ways in OHADA countries to take a security over receivables. This is the pledge of receivables and the assignment by way of security. So what are the differences here? Both circumstances we can pledge or assign the present and future receivables if they are sufficiently identified. The main difference here is that the assignment by way of security can be granted for the benefit only of a lender, a bank institution, and as from the signing date of the assignment, the bank acquires title to receivables. This is very important to keep in mind because this security is bankruptcy proof. It is very, very important. As from the signing date, the bank acquires title to receivables. Very important. However, the limit of this, the security, is that only financial banking institution can be beneficiary of the assignment by way of receivable, and it can secure only financial transaction, which means that a hedge counterparty and hedge instruments cannot be secured under an assignment by way of security. This is quite a strong limit to this instrument, and that's the reason why, for the time being, it has not been used so much in project finance transaction, where we have usually hedge counterparties. So that's all for the security of the receivables. Second security, which is very important in a project finance transaction, this is the security over the shares. Obviously, very important one. We have two types of security over shares in OHADA, and the difference is that how the shares are incorporated. If the shares are incorporated into certificate, which is the case in most of the situation, then a pledge over the shares will be granted over such shares. The pledge should be registered with the registry, and the enforcement could be done either by sale, by public auction, judicial attribution, or self-attribution, which is very, very important to note. The pledge over the securities account is with respect to corporations that whose shares are not incorporated in a certificate. They are actually represented by book entries in special accounts opened on the name of the shareholder, and they are held either by the issuer or an authorized financial intermediary. Having said that, not all OHADA countries have implemented a legal framework for the dematerialization of the shares. So presently, this type of security is not commonly used. And I may say that it's a shame because this security is not subject to registration, thus registration fees are not paid. This is quite interesting to note. However, we have seen this being implemented, for instance, in Cameroon, but in most of the other countries, we don't have yet the legal framework to do so. On the next slide, I just wanted to say a few words with respect to some less used securities in project finance transactions, the securities over movable assets. Why these are less used? Because it's honestly quite difficult to implement. For instance, if we take a pledge over stocks, the OHADA Uniform Acts provide that if you take a pledge over stocks, the value of the stock will need to be maintained still at the same level. So if you want to use the stocks, then you have to replace it with the same amount of or the same quantity of the kind of goods you are using. So this is a very difficult monitoring aspect. There is a difficult monitoring aspect, and also creates a kind of insecurity with respect of what is the asset that is securing your debt. So those kind of security are not so much used in a product finance transaction. And the final word with respect to the pledge of goodwill or ongoing business as well. This is the security that could be maybe the close equivalent of a floating charge under English law, because it includes almost all the assets of a debtor, of the business of a debtor. So it can be extended to the commercial lease, licenses, various IP rights, but also the professional equipment. However, this security is not so much used. Why? Because it's very, very, very complicated to enforce, and it is mostly considered as being a defensive security rather than a security that gives some much financial flows to the project. So I think that's all, and this is a good transition to my colleague Lucy to explain you how they take security under common law countries.
Thanks very much, Mariana. So in this part 2, we're going to be considering how taking security under English law differs from taking security under OHADA law. And as a general comment, and before we get started at looking at some of the differences, we wanted to point out that to the extent that you are planning on taking security or granting security in another common law based jurisdiction, so for example, Kenya or Ghana or Nigeria, the principles are likely to be similar to those under English law, but they're not necessarily going to be exactly the same, particularly when it comes to some of the more practical elements of taking security, such as registration or perfection or execution. So we would therefore always recommend that you seek the advice of local counsel to ascertain the precise requirements in the relevant jurisdiction. So how then do things differ under English law? Well, we heard from Mariana that under OHADA law, there are a number of different types of security interests. Under English law, it's a bit more straightforward. There are just 3 basic types of security. You have a charge, you have a mortgage, which includes security assignments, and pledges. Just very quickly then, in terms of the legal differences between 3 different types of security. A charge is an encumbrance over an asset. What does that mean? Well, what that means is in an enforcement scenario, you can appropriate that asset and you can apply the proceeds of sale in satisfaction of the debt. You don't get title and there's no right to possess the asset. And the charge might be fixed or it might be floating, which we'll come on to on the next few slides. A mortgage, on the other hand, involves a transfer of title to the asset by way of security. So this is on the express or the implied condition that the title will be retransferred back to the mortgagor when the debt is discharged. And similar to a charge, there's no right to possession. So I always think of a mortgage as a form of enhanced charge because you also get that transfer of title. And then finally, the other type of security interest is a pledge. Now, because a pledge requires delivery of possession of an asset to secure the debt, It's not something which we come across very often on the transactions that we are involved in, purely because it's not particularly practical for a company to hand over possession of its assets, which it might need on a daily basis. There's just one point that's not mentioned on the slide, but I thought it was worth flagging, is that under English law, we would not consider a guarantee to be a form of security. Rather, we would describe it as simply a contractual promise or undertaking to pay the debts of another party. So when you're looking at your English law loan agreement, you wouldn't normally expect to see a guarantee listed in the definition of security documents. So another difference between English law and OHADA law is that there is no prescribed form in which to document these different types of security interests. And in fact, you can do them all in one document if you need to. So you might have come across the term all assets debenture. Now, the best way to explain how an all assets debenture works is by simply showing you the main operative provision. So that's what we have done in this slide. So we've extracted the main operative provision here, which is clause 3, grant of security. And you can see here that there are a number of different types of security interests covering a number of different types of assets. So in 3.1, you have a legal mortgage over all of your property. In 3.2, you have a fixed charge over a number of different types of assets, but things like your equipment, your consents, your authorizations, your IP, money standing to the credit of your bank account. In 3.3, you've got a security assignment, so that, as we mentioned, that's just a form of mortgage. And then that covers your security assignment over certain material contracts and insurances we've got here. And then in 3.4, we have a floating charge, which I'll come on to talk about on the next slide. But there's just 2 points I wanted to mention first on security assignments that Mariana has already touched upon, but it's nevertheless worth flagging again, that under English law, there are no restrictions in terms of who you can grant a security assignment to, whereas under OHADA law, you can only grant an assignment by way of security to a financial institution in respect of a financial transaction. And then the other point that I wanted to just reiterate again that Mariana has already covered is that under English law you can assign contractual rights. You don't need to have a separate direct agreement. So moving on then, just to talk for a couple of minutes about the floating charge. So under English law, it's common to use a floating charge as a catch-all form of security to cover security which you haven't otherwise secured pursuant to your legal mortgage or your fixed charge or your security assignment. What is it? Well, it's a type of security which hovers over a fluctuating group of assets. So it can be present assets that are owned presently or future assets. And that floating charge will crystallize on certain events. And from that point onwards, the borrower is restricted in terms of what it can do with them. The point here is that there is no equivalent concept of a floating charge under OHADA law. As Mariana mentioned, it is now possible to grant security over future assets, but they have to be capable of being clearly identified at the time the security is granted. So there isn't quite the same flexibility there as there is with the English law concept of floating charge. So moving on, another key difference is that under English law, security can be held on trust by a security trustee. And that security is held on trust for a fluctuating group of beneficiaries. Now, under most civil law systems, and including OHADA law, the concept of a trust is not recognised. But as Mariana said, the OHADA Uniform Act on Security does now provide for a security agent. And this is what I call a hybrid between a civil law agent and the well-known security trustee. But that security agent may constitute, register, manage and enforce security interests on behalf of other creditors in its own name. And the security interests held by the security agent are segregated from its own assets on insolvency, with the result that there are very few practical differences between the security agent under the OHADA law and the well-known security trustee. Of course, the security agent remains a relatively new concept compared to the security trustee, who's been well known for hundreds of years under English law. But as I said, there are very few practical differences now. So another way in which English law differs is that it is generally a little bit easier to enforce security under English law. So you can enforce under English law at any time following an event of default. Now, there are different methods of enforcement depending on the nature of the secured assets, but generally there is no need to go to court. So just to give you a few examples, if you have a charge over a bank account, in an enforcement scenario, the security trustee or the lender that holds the security may simply set off the amounts in that account against the amounts owed to lenders or the secured parties. Similarly, if you have a charge over equipment, say solar panels, then in an enforcement scenario, the security trustee, the lenders could use their power of sale to sell those solar panels and use the proceeds of sale in order to pay off the outstanding debt. So that's that's the position under English law. At this point, I'm going to hand over back to Mariana to discuss some of the enforcement from an OHADA law perspective.
Thanks, Lucy. I think you've said almost everything which is very, very important under OHADA law, and you are almost now a civil law lawyer, as you know almost everything about OHADA law. But something quite important to note, this is that under OHADA law and all civil law countries, enforcement of a security is possible only following a non-payment. So even though in some circumstances it could be drafted in the security document that it could be enforced following the occurrence of an event of default, actually, if you go to the court, you will need to show that there is any sums that are due and unpaid under the facilities agreement to be in a position to enforce your security. This is a restriction, that's for sure. However, from a practical perspective, it's quite sure that you cannot really accelerate your loan and enforce the security if there is not any payment default. The other difference that Lucy mentioned is with respect to the method of enforcement. That's true that previously to the reform of the OHADA Uniform Act in 2010, it was quite difficult to enforce the security in OHADA jurisdictions because it was mainly a forced sale at public auction or a judicial attribution of pledged assets, which means that basically it took so long time to enforce and it was quite difficult that finally at the end the value of the assets was not really what it should have been if we have had a quite quick procedure. Now, in most of the security, we have the possibility to provide for a self-appropriation procedure, which is the possibility for the creditors to become the owner of the pledged asset following non-payment without going to the court. And as mentioned by Lucy as well, for instance, in a bank account pledge agreement, it's also possible to set off with the amount standing on the credit of a bank account in case of an event of default. So on the next slide, we would like just to say a few words with respect to the registration formalities. Under OHADA law, it is in the format. It's really formality. There are a lot of formalities to accomplish in order to have your security incorporated, perfected. Sorry. So the location of the registration varies depending on the type of the security, and the validity of the security registration is limited to 10 years. But of course, it can be renewed under the same conditions as the initial registration. And registration fees depend on the country on which the security is being taken and the type of the security being taken. They can be very high. For instance, in some countries, such as Senegal, it has been clarified that there is a lump sum to be paid in case of registration, because we have seen more and more very huge transactions in those countries, and fees were very, very expensive. But in other countries, this is not yet regulated, and it can be based on a sliding scale or a result of a fixed lump sum. It's very different from one country to another country, so we will advise you to take advice from a local council when taking security in a given country. With respect to English law and common law countries, I may hand you to you, Lucy, to explain how it works. You're on mute, I think.
There we go. Sorry. So under English law, registration is at just one place, at company's house. In terms of what needs to be registered, it is only security that is created by companies that are incorporated in England and Wales, or LLPs. So what this means is that if you have, for example, security which is granted by a Kenyan borrower or a Nigerian borrower under English law, it is not necessary to register that at company's house. There's no time limit on the validity of any security registration, so you don't have to worry about that. And if you're registering in England, then there are nominal registration fees only. I think it's something like £15 to register online, or 23 by paper application. But one point we wanted to flag here is that if you are registering security in any other common law based jurisdiction, this will not necessarily be the same. And we certainly see in some common law jurisdictions registration fees being very high. So to give you an example, Nigeria is one place in which registration and stamping fees are very high. So likewise, we would always recommend that you get the advice of local counsel early on in their transactions, so that you can make sure that you model any such registration fees early on. So that is, I think that rounds up everything for today. I'll pass now back to Kaushik to take us through some of the Q&A that's come in.
Thank you, Lucy. Thank you, Lucy, and thank you, Mariana, for a very informative run-through, Mariana, of all OHADA security and the types of security, and Lucy for drawing out those differences, the key differences between OHADA security and English law, common law security that's available. We've had a couple of questions come in. One for all of us, really. I could answer it, but I will maybe pick on Mariana to answer it. The question is, how do I ensure an OHADA security document works with my English law CTA? I'll pass that to you, Mariana, just in a second, and then I can also chip in. And a second question, which I'll pass to you, Lucy, is do I always need to use a debenture under English law? And you talked about this all assets debenture, but clearly in some project financings that are outside of England, it may not be required. So perhaps you could elaborate on that. But if I could turn to you first, Mariana, on how do I ensure an OHADA security document works with an English law CTA?
Thanks, Kaushik. I think it works well. We of course need to be sure that one of the things which is quite important is that the secured obligations are valid. But obviously, if you have drafted it, Kaushik, under English law, it should be valid then. But mostly, what is important is to keep attention on the drafting of the security documents themselves, rather than how the CTA should treat them. What is important, as I mentioned, is that when you have an English law CTA in a civil law country, and the commercial deal is to take a security over all the assets of a project company, then just keep in mind that you don't have a debenture, but you just have to analyze which kind of asset is worth. As I mentioned, it's quite difficult to take a security over stocks, over inventory, right? So just it's a balance to be reached between what is necessary, what is defensive, and what is very expensive or not.
Thanks, Mariana, for that. Just 1 second, I will put the camera back onto me. I agree with everything that you've said there, Mariana. It's certainly not unusual that a CTA will deal with both English law. An English law CTA will deal with both English law security agreements and refer to foreign law security documents. So in the case of OHADA, as Mariana points out, it's a question of making sure that all of the definitions work, and that's clearly something that we would be able to assist with. If I could turn to Lucy now, then in terms of this sort of debentures, all assets debenture, is that always required for a project financing?
So the short answer to that question is no. And in fact, it's been a very long time since I've drafted a full all assets debenture. And the reason for that is because most of the deals we do involve a borrower that is incorporated outside of England and Wales, that has relatively few assets with an English law connection or nexus. So, for example, you may have a Ghanaian incorporated borrower who might have a bank account in London, and it might be party to some English law governed contracts. Now, in that case, we'd obviously have some security that's granted under Ghanaian law, but for an English law perspective, we would have a charge over the bank accounts, and we would have a separate security assignment over those contractual rights under the English law governed contracts. So we wouldn't have an all assets debenture in that scenario.
Thanks for that, Lucy, and again, I agree wholeheartedly with everything that you've said, and I think it's a long time also since I've done on a project financing outside of the UK an English law all assets debenture. Not always unusual, and I think in the New York market, for example, it's certainly much more common to double up on security, particularly if you have a US-based lender. That's very often what is done. Part of the reason I think to avoid it is actually to avoid a conflict scenario. And if you're a lender or a group of lenders, clearly that is part of the consideration. And certainly if you're a borrower or sponsors, that should form part of the consideration, because you'll be potentially fighting lawsuits in multiple jurisdictions. However, if it's at the point that you've got to enforcement of security, probably the borrower doesn't really have a right or doesn't have a say in that. So I think typically doubling up on security is generally accepted as an acceptable way forward. But I agree, it's not necessary from a legal perspective. Just one other sort of final question. Mariana had talked about these on-demand guarantees. Now, in an English law sort of context, I guess that's typically a bond, a sort of an on-demand bond, for example, issued by an EPC contractor or its parent. Is there this form, Lucy, under English law that you would typically see in the same way that you would see under civil law jurisdictions, this sort of on-demand guarantee?
So we wouldn't normally see a on-demand guarantee containing, for example, reference to international rules on on-demand guarantees being provided by a corporate entity. We would only normally really expect that type of instrument to be provided by a bank or another financial institution. So it's simply not something which we come across under English law. It's not to say that it's impossible for a corporate entity to grant that type of instrument, but it's something that we simply do not see from an English law perspective.
Thanks for that. Again, agreed. Agreed with that analysis. I think that's it, really. Thank you once again, Mariana. Thank you, Lucy, for your very valued and valuable input and insight into security documents and the comparison between OHADA security and common law security. There are upcoming Trinity talks. We've moved now to a more monthly type of program. Previous talks are available via our website at trinitylp.com or on our YouTube page. We're always happy to be interactive, so please do feel free to send an email to any one of us, any one of your contacts at Trinity, if you want, for example, slides, or if you want specific training for your institution. But for now, I will leave you be and wish you a very pleasant rest of the day. And thanks again for joining. Bye-bye.